everybody. Welcome to the first learning circle of PUCAR in 2025 on multi-ODR systems. We're so glad to have entrepreneurs join us from across the ODR industry. Over the last 4 or 5 years, especially since COVID, ODR has taken a huge, there have been waves and waves of evolution with Gen AI, with the way summons work, process transformation, and I think most notably the recent Smart ODR portal and its collaboration with SEBI. So before we jump in to cover all of this, I just invite all of the entrepreneurs to introduce themselves. Vikas, do you want to start? And maybe you can, Rahul can go up after you.
Hi everyone. I think I've seen a lot of people around here. Vikas Mahendra. I am one of the co-founders of CORD, Center for Online Resolution of Disputes. Happy to be here and see what we can to share some of our learnings in the last couple of years.
Thank you, Vikas. Rahul, you want to go up?
Sure. Hi guys, I am Rahul Nanuhal. I'm the CEO of JustAct, dispute resolution platform, and happy to see you all here and share my notes and insights into this. Thank you.
Thank you, Rahul. Ishita, how about you?
Hi, good evening, everyone. My name is Ishita. I'm one of the co-founders of Webnyay, mainly looking after the product and tech. And I see a lot of familiar faces. I think it's going to be quite an exciting discussion. So looking forward.
Thank you, Ishita. Us too. Carol, do you want to go ahead and introduce yourself?
Sure. Hi, everyone. My name is Carol. I've joined from CADRE ODR. I take care of legal ops here. So yeah, happy, just like Ishita said, happy to be here and eager to learn more.
Thank you, Carol. Krunal, I don't see you on my screen, but I think you have...
Yes, I'm here.
Hi.
Good evening, everyone. Good to see everyone once again. I'm Krunal from Presolve. Happy to connect with everyone once again and share our insights on the topic. Looking forward. Thank you.
Thank you. And Paul, do you want to finish off?
Hi, so I'm Paul, and I work as a product manager with Summer. And so in the spirit of the learning circle, I'm super excited to learn from everybody on this call. Looking forward.
Thank you, Paul. So those are the entrepreneurs that have joined us today for the Learning Circle. And the first part that we'd like to discuss actually with the group is there's been a considerable movement in the way ODR has evolved since 2020. Of course, with COVID, there was a large part of disputes moving online. But today, ODR looks even different from what it initially began as, which was just an assisted mediation with technology. But there are far more process transformations that involve not replication of physical processes digitally. And Vikas, at this point, I'd like to invite you, what in your experience has been one of the, I guess, process transformations you've observed since 2020 in ODR?
Thanks, Rashika. There's actually been just so many of them that it's very difficult to put a finger on one or two of them. I think the scale of it is something that is not what we were fully prepared for. I know when we went into the EADR challenge now, 6 years ago, 5 years ago, they did say, how do you resolve 1 million disputes? But I think the reality of what 1 million disputes means only hits you once you start really getting into those, the hundreds and thousands and the 10,000s kind of a situation. So the process improvements that we've had to do are largely driven by what would be necessary to meet that kind of a scale. So that's been the biggest challenge that has been there. And scale compounded by the complexity of language, also compounded by the complexity of technological limitations. When we started off, I think the idea was, can we do a platform first approach? In fact, at the time, the buzzword was, can we do an app first approach? So, it was almost like you make an app and suddenly everything will be solved because people will have it on their phones, they can open it. But with fatigue now setting in, I don't think people are installing any apps, especially in the kind of situations where we're dealing with, where, let's say, for instance, we're talking about a bank or an NBFC or an e-commerce player trying to reach out to their consumers. Either the consumers, let's say they have a grievance, so they may have some interest to join the platform, in which case it's slightly easier getting to them. But in the situation where maybe something is being recovered from them, they're not very keen on coming in, let alone install an app and take things forward. So what we've had to do is actually move away from what we would have initially thought of as ODR tools. So actually, in a lot of our cases, we're not using Zoom or WebEx or Google Meet anymore. We are not even using video call in a lot of cases, because a lot of times when you're trying to reach tier 2 and tier 3 cities, internet penetration is so poor that you can only reach them on voice calls. So we have suddenly seen that in a very significant chunk of cases, a lot of the ODR hearings, the conversations are happening on phone rather than on a platform. Related to that is also, while typically we had a thought in an ODR platform will be where all of the information is based, and which is what it is today also, who is using that is slightly different. The people who are using that are now, let's say, for instance, corporations, because they want your MIS reporting systems, etc. So they want a lot of that information available on one place. But say the neutrals, to some extent, they're using it. There is still some reluctance of certain others to use it. But when there are individual complainants or respondents, it's very rare that they actually come onto the platform to access the information on that platform. So we've had to make some significant change to make this information accessible to them in the medium that they're most comfortable with. So that could be, for instance, if you're talking about email, some sophisticated players have email, so you send it across to them. But otherwise, in some cases, hard copy is the only way. So it is not a fully ODR journey in that sense of the term, but ultimately you want people to have something, so you send it across. But somewhere in between also, we are trying to explore multiple different avenues, right? Whether that is through WhatsApp or some such mechanism which is a little bit more accessible, which is a little more widespread than email and platforms, etc. The kind of things that we've had to deal with. And maybe I'll pause there because I'm on for an hour and more. Those are some of the things that we've been doing at Quad.
No, that's actually very interesting. And what I find is that, I remember our initial conversations would be about how do we move to adoption, but from the shift from adoption to accessibility, I find from how you're saying that, adoption was initially just regarded as get everybody on the portal. But I see that access means actually moving back a little to making it physical.
Yeah, so maybe since you did talk about accessibility, just one final thing I wanted to talk about, that language barrier has been something that has been a challenge, but we've made some significant strides both through technology and non-technological means. So we've initially started off with case managers and neutrals who were familiar with that particular language. But increasingly what we're doing is we're trying to use technology to bridge that gap. I mean, we are experimenting it with slightly more complex hearing. For instance, last week we were doing a hearing in Dubai where the client only spoke Arabic. The entire arbitration was in English. You didn't want the entire arbitration to become Arabic because then the tribunal wouldn't understand it, the other side's counsel wouldn't understand it. But then we used technology to make real-time translation available of the entire hearing. So the clients could now follow it in real time and then give instructions to the lawyers, receive it, etc. But that's the kind of technology we're trying to fine-tune to say, how can we use these large language models? How can we use these AI-based tools to make even ODR accessible to the most remote participants? And there we are trying just finding the right model, tweaking it to the right situation has also been something that we've been working on in recent times.
No, that's super interesting. And that actually brings us to the use of large language models with AI, because since November 20, the use of AI with ODR, since November 2022, everything sort of skyrocketed and Gen AI was trying to be used for every sort of tech startup. And I know that many of us used language models and saw the success of them also in terms of access, especially in a country like ours. But Ishita, at this point, I'd like to invite you and to see how you've used AI models for document management. I know that you've been experimenting with that at Webnyay.
Right. Thank you, Rastika, and thank you, Vikas. I couldn't have summarized that better with regards to leapfrogging into technology first, thinking of an app structure, and then slowly over the years realizing how we have to sort of customize or tailor the technology to the current situation. But having said that, we do essentially believe that digitizing all of the processes, introducing AI in ODR is the way forward, to sort of also bring about economies of scale and make sure that ODR is sustainable and cost effective in the longer run. So we were using AI in a variety of ways. It's not as jargon-like as it sounds to the end user. We essentially started out with the securities market. What we've done is created a data set of all the circulars, notifications published by SEBI, and we've embedded it all into like a contained generative AI sort of model. And the purpose of doing that was essentially to create a smart repository, like a smart FAQ section for investors, because at the beginning, I think in 2023, when the entire smart ODR regime launched, we had a lot of investors come to us with very basic questions. And these questions were essentially directed towards the case managers, which may or may not have had the best sort of answers to these questions. So we thought, instead of misdirecting, why don't we create a smart repository where they can interact with the documents that SEBI has sort of pushed out in real time and get these answers directly, only to now realize that this is now also being used by a lot of the market participants, a lot of the stockbrokers, which is great validation. But this is one of the ways. Another way that we're using AI is also for parties to create their document sets, their hearing bundles in a more sort of efficient manner. So a lot of the more time-consuming activities, like, converting OCR sort of scanned images into searchable text, or creating hyperlinked indices for the hearing bundles, is something that we've automated. So all in all, we're sort of leveraging AI for document review within a contained data set, as well as for some amount of compliance regulatory research.
And have you found that users are able to, like, users are spending lesser time now reviewing documents? Do you think that this is something that the users have since, have they validated this?
Absolutely. So, in fact, we've had the fortune of sitting down with some market participants and also some neutrals. So there are some sort of conciliators and arbitrators who have actively been using this to conduct their own research before drafting their settlement agreements or drafting their awards. And so we also sort of took them as our initial set of users to conduct, one-on-one trainings or do some beta testing with. And it's obviously great validation to hear that that their efforts and time have both reduced leveraging this tool.
No, thank you for sharing that, Ishita. I actually, before we spoke, I didn't know that we could use AI in the sort of document review that you were talking about. Like, research seems like an obvious answer, but to conduct an OCR and to automate the document dump, I think takes away a big pain from users. And I'd at this point also like to invite Carol, and I know that CADRE has been looking at user first, usability first as a key tenet of how they've been developing their platform. And Carol, I'd love to hear from you how you have found user needs evolve. What do you think, in your experience, have they liked? Have they wanted more? Have they found useful?
Like you said, Rashika, usability was one of our top priorities at CADRE from the very beginning, right? From the genesis of ODR itself. So a couple of things that we've done to push that forward and make sure that our platform is user-centric itself was we recently actually released our app, which is the CADRE app. And so we've taken all of that. Seems a little bit daunting on a desktop and reduced it down to something that you can download along with WhatsApp, right? So all of your notifications, everything at just at your fingertips, right? So that is something that they have really appreciated, we've seen, because it's right in front of them. They don't have to go anywhere to view anything about their case. Another thing that we've implemented in CADRE, like I think someone had mentioned earlier about languages, right? That is something that we've seen has really, really picked up with our users. So on CADRE, we have the ability to communicate in various languages at the same time, right? So for example, I would like to bring up a screenshot just as a visual aid, and it's just put into a document, so I apologize for that. But let me just share my screen really quickly. Give me 1 second. Okay. Oops. Right. Are we able to see the little screenshot that I've put here? You're able to see it? Sorry, I can't see if anyone's confirming.
Yes, we can see it.
Okay, great. So you can see here that actually one of the parties, they were more comfortable in communicating in Hindi. So they have put up like a few submissions of their own in Hindi directly. And for a conciliator who may or may not be able to understand or read Hindi, we have the option for them at a click of a button again to translate it into whichever language they feel they're comfortable with. And the reason why we feel like this has been quite useful is because I myself, I mean, I went from being a case officer to kind of hand holding other case officers now. I have seen myself that when a person is able to put their dispute in their own language, their boundaries fall down. You know, they're able to lay their defenses down and speak freely, therefore reaching a settlement quite faster. Right? Those are a couple of things that we've seen then and implemented at CADRE.
Thank you. Thank you for sharing, Zahil. Krunal, what in your experience have you felt that users have wanted? I know we spoke about integration of services, especially for cross-continent parties, and I'd love for you to share more about that.
Sure, sure. Firstly, thank you. Thank you for the platform and for initiating this discussion as well. Like Vikas earlier pointed out, ODR has grown leaps and bounds since 2019. And we've all witnessed that, Agami also being a key player in facilitating all these discussions has seen how ODR has grown over the last 5 to 7 years. When it comes to services and features that parties require, in our experience, e-sign, e-stamping has been one of the key services. Now, I can I can understand that for us, e-sign, e-stamping is something very common. Maybe because we interact with it on a day-to-day basis. We speak with people in circles that use it or implement it on a day-to-day basis. So we feel that, it's nothing really innovative, or it's nothing really out of the blue, nothing new. But that's not the same for parties, because parties at the grassroots level, whether they are individuals, whether MSMEs, they have not come across these services. So one such instance I would like to share. So this was one of the mediation cases referred to us by the Bombay High Court. It was a cross-border dispute. One party was based out of Pune, the other one was based out of Taiwan. And the settlement went through. But how do you execute that settlement agreement? So those, that was one instance when we realized the importance of these basic services like e-signing. After we spoke last week, Rashika, on this topic, there was one particular MSME based out of Madhya Pradesh. And that particular, proprietor was not able to sign the document using e-sign. So while the services are there, at the same time, we also need to spend some time to create sensitization and the awareness around how to use it. So that was one. The other service was, of course, is OCR. So like Ishita pointed out, OCR is something that can be used for summarizing documents. And at the same time, we've also seen the use case of OCR for registration. When parties upload documents automatically via OCR, basic details like name of the party, contact details are fetched directly onto the dispute registration form, and post that the dispute is registered. So it saves time and it saves manual error when it comes to filling all the details. And I think the other service is, of course, multilinguality. So parties are able to upload their side of the story over email, WhatsApp in their preferred language. And then once it's brought onto the platform, the neutrals and even the other parties are able to translate those communications into their preferred language. So these are some of the common services that we've seen has really, helped the parties, and also one of the reasons why ODR is really picking up. So yeah, that's probably about it from my side.
Thank you, Krunal. No, that's very useful to know, especially because On one hand, we're looking at how we can have physical copies of things delivered because that's how penetration happens in tier 2, tier 3 cities. But on the other, there is a whole gamut of work that's being done on integrating online for parties that are in different continents, which was sort of the hypothesis for ODR when we started. So it's great to see the range of evolution of ODR, especially from what you and Vikas shared. Lastly, Paul, I'd just like to ask you to share a few examples on how Sama has evolved notice delivery, whether through IVRS. I know I read a newspaper article about chocolates being delivered along with some notices. What does that look like at Sama?
Yeah, awesome. So I think the chocolate delivery was more like it was an experiment that we wanted to try, and sort of see can we incentivize people to participate in a conciliation mediation process. And while that saw its own it saw some level of success, I think there are certain restrictions that we also can do in partaking in that kind of activity. But when you touched upon IVRS, I think I can speak a little bit about that. So since for the past couple of years or so, Sama has been sort of in notice delivery. You can send notices, of course, you through the usual channels, which would be your email, SMS, WhatsApp, etc. And also, of course, do these automated voice calls. Right now, the problem with all of these is that it's all static information. So it really relies on the other party at the other end being motivated enough to understand first what information is being given to them, whether in the SMS or the legal notice that they receive, what all is there, what all is conciliation actually entail, how is this going to help me, all of that. So one of the things that we've been doing recently is we partnered with this startup called Arrowhead. And what Arrowhead does is they have these, it's like an AI bot that does voice calls. And so the difference there is that once you receive a notice and you get a call from the bot actually does a good job of explaining what the notice contains and what exactly the expectation is from the other party on the other side. And the reason why this is super useful, and we have been seeing relative to what earlier numbers that we were seeing, there's definitely a lot more success with this. Primarily, I feel is because the bot allows you to understand where along the journey the party is at the other side, right? So, for example, if you have 100 cases, 100 different respondents will all be at different levels of understanding about the legal landscape or what mediation is, etc., who Sama is, all of those. So some may be a lot more equipped and some may not be as equipped. So when you have an AI bot that is actually doing this call instead of an automated IVR type of call, which is static content, the AI bot can sort of speak and understand what kind of user you are, where along the journey are you? Are you someone who's really technologically advanced and understands how exactly ODR works? You understand what Sama's role is, versus are you way lower down the line and you have no idea what is ODR? Why am I getting this notice? So it sort of can bridge that gap in understanding, which really helps. And I think what's useful to understand about this also was in one of our own interactions with enterprises, they praised ODR as a awareness device. So they saw ODR as being this opportunity for respondents to understand how do what all consequences can come if you don't participate in this ODR process, for example. So they really take it as, hey, here's a neutral party that can explain to you what all your rights are, and then what all you can do before this becomes an actual case in court. And so from that perspective, using these notice delivery mechanisms, which are slightly more dynamic. So I think we want to try and redesign that entire experience of how you receive a notice and how parties are going to understand what is in the notice. Because that is the first layer of communication that they receive, right? So I think more and more innovation in that is obviously going to help a lot more. I think that's something that is unique to ODR so far, right? In the way that I know there's some work on summons being redesigned also, which I think some of the PUCAR folks are doing, but along those lines itself is how can you get people to participate in this and meet them where they are in terms of their comprehension ability and things like that.
Thank you, Paul. No, I think the focus on usability and access I think permeates most of the evolution that we've discussed about ODR in the last 20 minutes. And I think that actually serves as a great starting ground to look at one of the collaborations that's excited me the most, which is on smart ODR, which is the multi-ODR approach. I think it's the first time that multiple ODR startups have been empaneled to a portal and get assigned disputes to then resolve, and then it moves back into the system with SEBI as the regulator. Being this the grievance redressal mechanism for investors, I wanted to throw this question open to all the entrepreneurs and others in the room as well. How has the multi-ODR process or multi-ODR system been over the last year in some change? What have been some of the big learnings? And more importantly, do you as entrepreneurs see this as a system that could be adopted by other ecosystems?
Hi, Rashika. Happy to get the ball rolling. I'll start off by saying it's been an absolute massive pain in terms of a lot of the things we've had to do. But I say that in a sense that it's been a huge learning. I think not just for us, for the regulator, the parties who've been involved also, and I'm sure Paul and team at Sama will echo the sentiment of how much work has been done because they've built that smart ODR framework. So if we've had to deal with X, they would have had to deal with 10X, the kind of things that we've had to deal with. To answer your question, I think it's an incredible model to follow. And I'll tell you why for a couple of reasons I feel. One is the biggest challenge with ODR was credibility, especially in today's age of digital arrests and people don't know whether everything that's happening with ODR is even legitimate or otherwise. For a regulator to come in and say, there is a stamp of authority, there is a stamp of credibility with X number of institutions. And that is not a credibility that's coming in just like that, right? There is actually a lot of work that's gone on behind the scenes, and there's a huge amount of accountability that is being brought in by virtue of that. For instance, in the SEBI framework, there's strict adherence to timelines. If a conciliation has to happen within 21 days, it absolutely must. Otherwise, we work with the NSE, we get hounded by them, like literally 2 calls a day, 3 calls a day, emails multiple times. And that's the kind of oversight that is being maintained to ensure that whatever, whether that is turnaround times, whether it is the cost, whether it is the quality parameters, are adhered to. So I think that kind of framework keeps both the ODR institutions in check and also gives the user some degree of predictability in terms of processes, outcomes, etc. I also think it's great because it suddenly makes the most difficult kind of dispute coming into ODR. What I mean by that is, we've seen a lot of banks and NBFCs adopt online dispute resolution. And why is that? Because they are the ones who draft the contract. They are the ones who have a reason to go after your individual borrowers to get the money. So for them, incorporating an ODR clause is a relatively straightforward process. But the minute it comes to the other way around, let's say an individual consumer has to file a grievance against a bigger enterprise. The enterprise has no real reason to actually make it easier for the consumer. And we've seen this in a lot of cases where they've said, listen, I've given them my consumer helpline number. If that hasn't failed, why should I make it easier for these people? Has been the general tendency. And that's why the adoption of ODR in the sectors where consumers are trying to file grievances against the bigger corporations has been not as much as it is the other way around. But with someone like a SEBI coming in, that is exactly what is in the focus. If you look at the entire ODR framework under the SEBI circular, it is those kind of disputes where individual trading members, individual investors have a dispute with their trading members that is coming in. So you're encouraging those kind of disputes. So I think, and there's multiple others, and I'm sure others will speak of it, but these are 2 things for me that really stand out. One is, of course, the credibility and the regulation that comes around with it. And the second one is really opening it out to proper resolution by aggrieved consumers, etc. And that's also the reason why people like RBI are interested. So when I was speaking to them 3-4 days ago, we were giving them a training session. They were really, really interested in this. Like there was a good half an hour, 1 hour devoted to them understanding, and they were the consumer education and protection wing of the RBI, right? So they're really looking at how can I make it easier for my consumers? And this was a bunch of 26 ombudsmen who had gathered together. So this is all people who are in that space of resolving complaints. And they were really keen on how is it that we can adopt ODR, whether this is the right framework, whether RBI should do something. Should RBI enter into it at all? Will ODR become a regulated entity? What are the consequences? So it's a whole Pandora's box, but I think there's a lot of interest and I think there's a lot of potential as well.
Thank you, Vikas, for sharing. I think I hear you on the concerns for does this make ODR regulated? And, one of the things I wanted to flag, and I wonder, Vikas, or if anybody else would like to take it up, is do you think there is the need for standardization of certain elements of the ODR process because of this fear as more and more that it enters regulated or ecosystem spaces? Do you think that there is a degree of standards that need to be set, whether they're data standards or they're standards on protocol for what happens after an interim award, how long? I mean, I know there is a law behind it, but within ODR setups, do any of you see the need for standards like that?
So I'm probably the villain in the room because I'm an ODR player who's advocating for regulation. But that's actually what I feel truly as an ADR ODR practitioner. A lot of the ODR movement has been hit by some practices which have not been in sync with the broader objectives of when ODR started, right? For instance, if you're talking about, and I've raised a couple of these on forums, which a lot of people on this call are a part of, right? So for instance, are ODR institutions handling cases that they should not be handling? And how is that being taken care of? How is it that, let's say, for instance, if they are going with going for ex parte awards because the party hasn't appeared, then at what point in time is it okay for you to start going down that path? What sort of access are you making available? And these are the kind of things that ODR said we're going to make an improvement on in existing processes. So if you thought about how, let's say, the NBFC banking sector used to operate earlier, they used to give, 800 rupees to one lawyer. The lawyer would say, okay, I'm going to appoint an arbitrator. I'm going to dispatch all the notices. I'm going to give you an award, which is an award under the Arbitration Conciliation Act, which you can go enforce. But obviously the flip side of that was, the hearing was in some, maybe a Bombay or a Chennai or something, which basically meant no one ever appeared. And even though the notices were dispatched in a manner that, you didn't really want people to come at all. So you almost designed the process such that the party is not going to come and appear at all. And ODR said, we're going to make a difference to that. We're going to ensure that, we make it accessible. We're going to make it more affordable, all of those things. But I think there are some practices which have started creeping in, which, whether driven by financial motives, whether driven by efficiency motives or whatever, are making it, there's a little bit of a friction between accessibility and efficiency there. And I think whenever there is that friction, there is need for someone slightly independent to say, hey, this is acceptable, this is not. I don't think the regulator also will be interested in something very specific and pedantic, but I think some guardrails are necessary. And I think that those guardrails will also mean what I talked about, credibility, right? You suddenly start weeding out people who are not complying with that. Rather than today, the framework is that tomorrow I can decide I'm an ADR institution or an ODR institution, and I am an ADR institution. There's no registration that is necessary. There is no requirements prescribed under the Arbitration Conciliation Act. Those, I think, are slightly risky. I think there is some degree of accountability that even ODR institutions must have. And today we don't have it. And I think some degree of regulation is necessary.
No, thank you for sharing, Vikas. I think I hear you on some degree of regulation is necessary. I really wonder what form of regulation that would look like, because I think the devil really lies in the details there. Because if you had a law that mandated things, the whole point of ODR was that it stepped away from the whole field of this is the way, or these are the processes, but the ability to innovate. And I wonder how regulation will shape, or what type of regulation that could be, if it could be self-regulated. There's certain jurisdictions I know that self-regulate even ADR practices. So that would be super interesting to know how ODR would evolve into regulation. But I wonder, Paul, are there any challenges that you want to address with smart ODR, or anything specific in terms of your experience with SEBI in the last year and a half that has led you to believe that multi-ODR there may be a future for such a system?
Yeah, I think like riding on a lot of what Vikas said, I definitely echoed a lot of those sentiments also. Largely, the credibility angle has really helped in ensuring that this system works and has teeth. So there is like an outcome that happens within a fixed timeline. Um, and the timelines are really strictly adhered to. I think just from like a sustainability point of view, for this system to continue, I think standardization process would really help. In the sense that right now, a lot of the uh, requirements that are needed to publish for an ODR institution per case, for example, is extensive. There's around somewhere close to 100 data points per case that need to be published at the end of a case lifecycle. And so the way to do that at a scalable way will only be if all of this is enabled through API integration between ODR institutions and any sort of multi ODR system. So if for smart ODR and any other multi ODR system that is in place, I think standardization of those APIs would really help because they are going to be similar. They are going to be around your how does a dispute transfer from one from the portal to an ODR institution? How does data flow back from the ODR institution to the multi ODR system? What all kind of reporting do you need? So I think there's already work in that direction, which has been done, for example, by the backend folks and things. I think implementation wise, there is things which are still pending, right? I don't think there's any system which uses that protocol yet. But along those lines itself, I think is where you want those data standardization practices. I even think for mediators and arbitrators, also for these ODI solutions, maybe there is standardization on how they enroll, who's qualified to be a mediator, who's qualified to be an arbitrator. And I'm sure the arbitration council, mediation council, things like that will come into place in some time. But until then, is there a need for like a self-regulatory body? Or things like that. And can ODI institutions come together and then prescribe, okay, these are API specifications that we want to follow, or adopt a common protocol for these are how these APIs need to be structured. So those kind of like standardization process, I feel for sure are necessary if you want to scale these systems in the future. Because today, if you have like say 100, whatever, like 1,000 cases, you can still somehow do it in the old-fashioned manual way of updating data points one by one. But the minute that becomes tens of thousands of cases, obviously not going to work. So it's actually critical for these systems to adopt some sort of standardization practices so that the system can scale reliably.
No, thank you. Thank you for that's very interesting, actually. On one hand, credibility, but on the other, even to manage scale, standardization seems like, or some degree of standards seem necessary. Thank you so much, everybody, for sharing. I'd like to invite the audience, if you have any questions for the entrepreneurs, now's the time. Please raise your hands. Rahul, go ahead, followed by Mohit. Yes.
Hi, look, really, really wonderful hearing all these stories. I was wondering, Smart ODR is such a success. What will it take to scale the Smart ODR type system to some of the other, the thing that leaps to mind is DPDP says that it needs to be a digital office for, and the DPDP board, the data protection board is a digital office. It seems ideal for what you've built for SEBI to actually transplant into DPDP. So the question really is, what will it take to implement something like this into the data protection framework, and how easily or quickly can we do it? Just an idea, because I think one good implementation is great, but two just shows that this is a completely scalable way to do things.
I mean, just off the top of my head, the way that I can see it is you can have a protocol in place for all of these, like the way ODI institutions communicate with any sort of system, multi ODR system or otherwise. So similar to Smart ODR, you could have either whether it's another portal of sorts for for whatever the DPDP Act is prescribing. And then once those APIs sort of are standardized, then you can use any portal for any sort of dispute resolution to then, because today also technically the format for Smart ODR is very straightforward. It's a form that someone is filling with their dispute details, and then it goes to an ODR institution for mediation or arbitration. So now that same framework you can really apply for any kind of use case. Right now, Smart ODR is localized to the securities market, but that system is the same. It would be collect data at one level and then whether it's a round robin process or whatever, allocate it to different ODR institutions, and then have it report back in a prescribed in some format. So yeah, that's what I feel.
Yeah. No, just leading on from that one, Rahul, I think the model at that basic level is going to be similar. But I think what we need to do if another regulator needs to adopt it is actually some degree of homework. For instance, if you look at the SEBI's ODR framework, also Smart ODR, they started off first with dispute classification, identifying what are the different categories of disputes. In each category of disputes, what are typically the kind of documents that are necessary? What are typically the kind of issues that are faced? So you start structuring data input from the get-go so that those 100 data points that Paul was talking about are then more easily populatable, because then your MIS reporting becomes easier, tracking on both sides of the equation, the party complaining, the party against whom it's complained becomes easier, and for the regulator also to keep a track on what sort of disputes are arising, what sort of disputes are being fought through, what sort of claim values are being given for which kind of an issue, start becoming clearer, so they can start taking preemptive actions. They can start forecasting to say, okay, this is an area that is becoming a concern, this new app has started causing problems, whatever. Those kind of analytics will be possible if we spend some amount of time structuring that initial case intake. Once that case intake is properly structured, like Paul mentioned, the processes of how data flows from one agency to the other, one platform to the other, those are already set, and I think those are replicable. The one final thing you could possibly also add is getting information from the credible source automatically. So one of the issues that we're facing in the Smart ODR problem is when, let's say, there is a trading member against whom a complaint is filed, and that trading member needs to disclose certain amount of information as to what happened to those transactions. Were those settlements made? When was the request made? When was the actual transaction? Those are now manually being entered onto the platform. Now, if these kind of information can be pulled from the relevant entity automatically, then you maintain the credibility of the information, so there's no tampering of information, etc., and you can do things a lot quicker. So I think that is one other step I would recommend if another agency or a regulator is looking at it. Take the SEBI model, spend some time getting the case intake right, and then see if there is some degree of integration which will allow most commonly used information to be automatically fetched from the relevant players.
Very useful. I was just wondering if I know this is not written because you guys just did it on the fly, but if there's like a one pager or something that can be done, because I know that they're looking right now to set something up for the Data Protection Board. I think Meeti is responsible for doing that. It'll be great if there's a workflow or something that you can write up in a page that could perhaps be a starting point, not to give you guys more work than you already have.
No, actually, in fact, we've made some similar pitch to the EPFO, Rahul. So the EPFO and the RBI, both of whom we have submitted a couple of white papers where we have recommended adoption of a SEBI kind of model for their internal grievance redressal ombudsman kind of mechanism. So I'm happy to convert that into something that is appropriate for the DPDO and send that across to you. I can take the lead on that.
Perfect. Thanks so much. And congratulations, everyone. Really, really wonderful to hear all these stories.
Yeah, Rahulji, just to add on to what Vikasji and Paul actually has shared, I think beautiful points both of them have put across. Just to add one more point is that some sort of a standardization, as what Vikasji was telling earlier, we can also have in terms of DPDP, in terms of having certain ISO 2000 or some certification in hand, which will authenticate or which will validate that all the data that resides within the ODR or the institution is actually secure. So that will also go a long way in actually validating that the data protection laws are there. And just my 2 cents
there. Thank you, Rahul. If there are no further follow-ups, Ishita, Carol, I'll move on to the next question from Mohit.
Yeah. Hi, Rachika. Thank you. Hello, everyone. Thank you for such a wonderful discussion. Just from what I've gathered, I really understand that the tech has been adapting to the market needs and demands. And as such, if please correct me if I'm wrong, ODR has also evolved in a way where arbitration is seeing more use than mediation. And so even the tech that is being developed around ODR, I feel is more arbitration centric, more document centric, more delivery of notice, delivery of award, e-signing, e-stamping, right, live translation. Uh, so the question I have is, from the perspective of just innovation, and what kind of tech innovation do you think would be useful to also benefit mediation as such? If you have any thoughts on this, thank you.
Uh, okay, yeah, Vikasji, please. Okay, thank you. So I think, Mohit, a very valid question, considering that most of the parties or people at large have this question about like institutions focusing more on arbitration. I think I would like to say for JustAct, and what I believe is for most of the other ODRs, is what I also feel is that we always push for mediation first as much as possible, and then go for arbitration. And when we look at the tech building for mediation, it's pretty much aligned with our product roadmap for arbitration as well. For example, as initially when we had the discussion started and people were talking about accessibility, large language models, building smart tech into which is inclusive for everyone, having the documentation, bundling, and all those kind of features for arbitration. They work well for mediation as well. So we are keeping the focus aligned towards building a smarter tech for mediation as well. So in that, obviously, the inclusivity in terms of the language, because the language of mediator, offline, we can have the mediator talking the same language as the claimant or the respondent. So, but online, we can also have inclusivity in terms of data translation or using AI models to actually have a better transcription of the entire platform, and document bundling, case discovery as well. So the tech is not different, Moji. It's just about priorities in terms of what we want to offer to the stakeholders of the ecosystem at large. And I would say from I think our company and what I feel for other ODRs as well, we're always trying to push mediation first, and then that succeeds. I think nothing like it, and then obviously the final answer resides in arbitration if that doesn't happen. Over to you, Vikasi.
I think Ishita had something to say. Sorry, I've spoken too much. Please, Ishita.
Oh, you can go ahead, because that's fine. I can go after you.
No, I probably have a slightly contrary. No, please go ahead.
Okay, sure. So I think, Mohit, with regards to technological innovation, I think mediation in itself has an intent, shows some sort of an intent to resolve mutually. So I guess there is more innovation perceivably being happening on the arbitration side, but I assure you that there is enough happening with regards to mediation as well, basis the nature of what the dispute is, basis how comfortable we feel the sort of, I would say, investor or borrower is, what is their sort of proficiency with technology, whether they're native, like digitally native, or comfortable or new to tech. I think there is some amount of segmentation happening where we try to assess how comfortable they are with technology, which language they're more comfortable with. So I think these sort of preliminary segmentations are happening even before we sort of go into resolving the dispute. I think every platform is probably doing it differently. Some are enabling this with the use of tech. Some are probably doing it manually. But there is enough innovation happening even on the mediation front. I think there's more that you can document with regards to arbitration. So maybe it seems that there is perhaps more happening on arbitration, but there is plenty happening.
So sorry, my sense in this is slightly different from what I thought about a few years ago. So let me share. I think we have moved as an organization away from pure arbitration and pure mediation. And I think that's the ecosystem as a whole that we're seeing. What do I mean by that? If you look at an arbitration, take the NBFC banking sector as a typical example where, they come to you saying, listen, we have an arbitration clause where, we potentially have your institution in it. So please ensure you go through it and give us an arbitral award. Obviously, tech innovations happen to enable that. But like Rahul and Ishita have mentioned, all of these tech innovations also encourage mediation. Even in those kind of cases, arbitration is actually not a result that most banks or NBFCs are the most happy with. Right? Because ultimately you get an award, they still need to go and enforce it, and enforcement is a huge pain, as all of us know. So what has happened is, even in the arbitration process flow itself, as the Arbitration Act itself allows, the arbitrator's role has now become a little bit more of, listen, do you want to try and settle this matter? Is there some scope for settlement? So in an arbitration process, there is a lot more mediation happening than it was happening historically. There again, it's because the issues are relatively straightforward, so there's maybe not too much to decide. There are these outlier cases where someone comes and says, I've already made payment of the loan, not reflected, account is not up to date, things like that. They're minor issues, but in the vast majority of the cases we've seen is that most people recognize that there is a loan, there is a default. It's about how do you take it forward. So that's where I was talking about arbitration no longer being the pure arbitration the way I had initially thought it might be. On the other end of the spectrum, we've also seen mediation not being pure mediation the way I had seen it. For instance, we've got a lot of cases where a consumer complaint has been filed across multiple district consumer commissions or state consumer commissions across the country. The companies come to us and they've said, listen, I really want to reduce the number of disputes on my balance sheet. I don't want these number of disputes. Can you please reach out to these people and try and see if some sort of a negotiation mediation is possible? In those kind of cases, what typically happens is, we have used the same innovations that we've used for arbitration, which is to reach out to these people in their language, in the kind of notice formats that will encourage parties to come onto the platform. And there we have started to use mediation to try and facilitate some degree of resolution and say, why do you want to go to court, try and do it. But even there, it is not pure mediation. And this again is an experience which is consistent with what we heard from the RBI also, which is they said, listen, in these kind of simple cases, there is a right and wrong. Either, for instance, if you're talking about a bank, did you go and withdraw money from the ATM? Did it deduct it from your account? Did you get the money? Unless you decide some of these issues, trying to mediate and settle in thin air makes no sense. So I think even in those pure play mediations, we are seeing some hybrid where there is some degree of determination, some degree of, this neutral will say, listen, in my view, I think, he tried to withdraw the money. He didn't get it. So do you want to see if there is something you want to give him to try and settle this dispute? So we are seeing in mediation also a combination of decision making, which is typically in the realm of arbitration, but mediation, which is more in the sense of, how do you want to pay? How much do you want to pay? Which is a little bit more negotiation, mediation based. And that's consistent with what we're doing in the SEBI also. If you look at the SEBI framework, the first step there is conciliation. And that is absolutely not mediation, because the conciliator at the end of that process is supposed to draw up a conciliation report. In the conciliation report, that conciliator is supposed to make a decision on what his or her view is as to what has happened on that matter. Right? And that is not at all what a mediator typically does. So that's why I was saying that even in those sectors, mediation is no longer pure play. So I think we should move away, at least personal realization is that we really should move away from this pigeonholes of arbitration, mediation, conciliation, because now it's become a lot more fluid. And I'm seeing a lot more of this hybrid approach of maybe some decision making followed by negotiation is probably a far more viable hybrid than thinking of it in silos.
No, thank you for that. I think that does help. It's also got me thinking about how tech for mediation could also look to empower parties, right? And that's also a big thing that I've heard around today. But thank you for these insights. I don't have any further questions. Thank you.
Thank you, Mohit, and everybody for sharing. Are there any other questions from the audience? If not, I think I'm going to be the first person to end a learning circle on time. So I'm going to very quickly thank you everybody for joining, and more importantly, I'd like to do a...
I think Chitra has raised her hand.
Oh, I'm so sorry, Chitra. Please go ahead.
Thanks. Sorry for disrupting your scheduling, but what problems everyone has faced? Can I hear a little more about that? Vikas mentioned a little bit, but the need for standardizing, but why? And are there any issues? Um, uh, so that's my question, really. I was hoping to hear a little more about what's not gone well.
Sorry, I feel like this first bencher in college again. But no, Chitra, I think a lot has gone well, but I think in the process, a lot of things which have not gone well have also bubbled up. So to give you a few examples, when we are looking at resolving disputes at scale, one of the things that you really want to do is efficiency. Like you want to ensure that it now becomes this absolutely clean factory pipeline kind of a process, because otherwise you're simply not in a process to handle the tens of thousands of cases. What I think has happened in that process is, to some extent, the willingness of parties, particularly neutrals in the process, to apply their mind to each case has reduced over time. And that's been our own experience. Like initially we found that a lot of neutrals came in, they were willing to devote the amount of time, they were willing to devote the kind of effort that is necessary to resolve a dispute. But in recent times, the people want it to be a little bit more standardized. Listen, I don't have time for this. Give me everything. I just want to sign and be done with it. Kind of a mindset is creeping in. That for me is a problem, because we are not here to rubber stamp what one party might say or otherwise, however simple, however straightforward that might be. Even if it is 30 seconds, even if it is 1 minute or 2 minutes that the neutral has to apply their mind, that application of mind has to happen. And we're seeing increasingly that that is becoming a problem, particularly in the arbitration workflow. Second, I think commercials have started posing a huge challenge for us. We are today receiving requests for the entire process to be done in, let's say, 600 rupees or 800 rupees, end-to-end arbitrator fee, institution fees, everything together. I'm not saying that's a bad thing, because if you look at it, courts work that way. Judges, if you do the numbers, are probably earning 50 rupees or 60 rupees a case, maybe even lesser, right? So it's not that it's not possible. But that, unfortunately, I think is coming in certain streams at the cost of the first point, which is I made, which is you really should be resolvers, not rubber stampers. And I think that is a challenge again that we're facing. And because the financial incentives of an ODR institution is slightly at odds with this need for neutrality, due process, all of those wonderful things that ODR came up with, some degree of external oversight, whether it's self-regulation, whether it's a regulator, I feel is necessary to ensure that we don't lose our way too much in this quest for efficiency.
Thanks, Vikas.
I'd just like to add on to Vikas's point. I think to the first point that Vikas mentioned, that there is neutrals have sort of, in my opinion, they've started heavily depending on case managers to be taking a lot of the workload that they are to be doing. There are a lot of instances that we're seeing in which case managers are being asked to take on their share of the work, draft things that they're not supposed to be drafting, because in the very essence, case managers should just be supporting the parties with the processes. And while the entire concept of case management is quite wonderful in itself, because it's sort of like a category creation of profiles, the dependence on them for non-administrative work, in my opinion, should be reduced by a large measure. Just another challenge that I would like to add on is there is still very little knowledge about the entire process of ODR and even smart ODR, and the difference between smart ODR and how it is led to other sort of ODRs. So I think because we constantly face a lot of requests on, I did this on smart ODR, I'm coming to your platform. How do I go back and move my dispute from this place to this place? So I think as a collective, I think we can take it upon ourselves to, in fact, create a lot more awareness, not just about the legal processes, but also the processes in general around how to file disputes, how to manage their disputes more effectively.
Just piggybacking off of Ishita, and like I 100% agree with that. I think the novelty of the entire process itself serves as some sort of a hindrance sometimes, right? We've seen, especially in the securities market, because they're so used to having someone to speak to. They go to the NSE office and speak to someone directly there, right? So now there's all of a sudden seeing that, no, I can only meet you on screen. I can't really look into your eyes and tell like what's going on in your mind. So I think that is I 100% agree there, and agree on the second part as well, is that all ODRs as a collective collaboratively need to push the awareness of that. Yes, we are here. You can depend on us. We are completely neutral, and we're here to help you. And just like going back to what Mohit mentioned as well, because I wasn't able to unmute at the time, like Vikas was saying, it is a marriage of all the different types of resolutions that we have, right? Conciliation, mediation, negotiation, and arbitration. I think no longer can we hold them all exclusive, right? I was speaking to another arbitrator the other day who said that you pay me only for arbitration, but I'm doing all four just to get them on one page. So that way, the technology that we are developing in ODR as well also serves those purposes. Like when you have the ability to see if someone has read a message, or the complete transparency of the entire process, that also helps to assure the other party that it is completely transparent. We're not on the other side, right? So I think that adds up to that. Sorry, a little bit fumbled on the progress of that communication.
Yeah. So Chitraji, adding on to what Carol, Ishita, and Vikasi shared and all. I mean the need for standardization was your question. One aspect I would like to add is about the future potential risk that any new ODR coming up can potentially share. For example, bypassing any process, bypassing the data protection that they need to do. So some sort of standardization as to what they need to do at a basic minimum to have the authenticity, to have the validation of being called as an ODR, that they need to must comply, so that that respect for ODR as an institution is maintained. So whatever hard work all these guys have done, especially who have been working for 2019 onwards and before that also, so that doesn't reflect for them, because they have worked very hard to spread awareness and build trust among people, to have ODR as a trustworthy place. Someone coming in and bypassing the process just to give, like what Vikas was saying, as a bad commercials which are like unbelievable sort of a thing. They can only do by bypassing certain processes, probably certain compliances, data protection requirements, and all. So if we have this, we can also avoid potential risks in future, not just for the parties involved, but for the ODR at large. Have the trust for them.
Thank you, everyone.
Thank you everybody for sharing. I will reach out to Rahul to see how we can action that note, and any other opportunities or challenges that we discuss. Please feel free to reach out to me, and I'd love to help facilitate that. Thank you everybody for joining, and Vikas, Carol, Rahul, Ishita, Paul, Krunal, for sharing your stories and rich insights. It really has helped shine a light on what ODR has been up to in the last 4 years. And I think what's been most interesting for me is that the challenges that I thought would be challenges, which were challenges in 2019 about adoption or integration, are really some of the opportunities that are being presented about how much adoption there is and how there is credibility. And the challenges are now moving into far more the way any nascent industry, I guess, is, whether the commercials or otherwise. So super exciting. Do feel free to write to me. I will leave the email addresses of all the entrepreneurs in case anybody wants to reach out to them directly. But thank you for joining us, and we will see you again at the next Learning Circle.
Thanks a lot.
Thank
Thank
you.
you. Thank you, everyone.
Thank you.
Bye-bye.
Thank you.
Thanks, guys.
1 second, I've got to stop recording.